Good evening, everybody who's come to attend this, join in this discussion on neutrality and independence in the appointment of Chief Election Commissioner and Election Commissioners of India. Now, this, I guess, as all of you know, this topic arises from a judgment that the Supreme Court recently gave on this issue. In the case which has come to be known as Anup Baranwal versus the Union of India. The main judgment is 289 pages, and there is also a concurring judgment by Justice Rastogi, which also runs into 89 pages. So it totals up to 376 pages. As I am sure all of us will agree, nobody reads a 376-page Supreme Court judgment for fun. It is not a novel. It is not a non-fiction that one is interested in, unless it is prescribed in a legal course. Then I don't think anybody would do this. So I ended up doing this because I was asked by the organizers to do this session. So I would like to thank the organizers to make me do this, because it is certainly worth reading, and I enjoyed that experience. Given that it is such a long judgment, it covers a large number of issues. So it is obviously not possible to cover the entire judgment. So I will therefore focus on certain parts of the judgment, which I think are appropriate or relevant to the topic today. And I will also I will also read parts of the judgment, because I think the way the bench has expressed itself, I can do no better in trying to summarize or put it in my own words. Now, before I do that, let me say upfront that on the whole, I think it is a very good judgment. One could even call it a landmark. But being an activist that I am, I think this breed of teachers called activists are never satisfied with what they get. They always keep looking for more. So I think while the judgment is very good, might well be a landmark, but I am sure more could be done. But I must also admit that the court has done what it had been requested to do. What becomes as more that could be done is an afterthought, and I will share that afterthought with you once I am through with the judgment. In terms of criticisms, of which there have been plenty, the main criticism of the judgment by those who do not agree with it or who think it is a wrong judgment, the main criticism has been that the judiciary has encroached into the field of the legislature. Now, this is not a new phenomenon, and I actually became acquainted with this phenomenon way back in 2002 during the first series of ADR judgments that we went through. I will I'll perhaps comment on this in a little more detail when we come to it. But in my view, the criticism is not valid. Now, I will go through this in a number of parts. First, I will give you a broad view of the judgment, and then I'll get into specific issues. And those issues, I think I will cover independence, which is part of the topic for today. Then there's a very interesting section in the judgment called pursuit of power. Then there is a section on separation of powers. And then there is a section which says, is there a vacuum? And if there is a vacuum, should the court step in to try and fill that vacuum? That section is the answer to the criticism that the court has ventured into the legislative arena. So we will discuss that bit at that time. Then I will sort of end with the so-called afterword that I said is an afterthought. So to give you the overview of the judgment, actually the judgment is in response to 4 petitions. It is not just one petition. The first petition was filed in 2015 by a lawyer by the name Mr. Anup Baranwal, whose name the petition carries. And my information that I have tried to collect tells me that Mr. Baranwal filed the petition and then they approached Mr. Prashant Bhushan, who is a well-known public litigation lawyer, asked him to argue it. And the subsequent petition was filed in 2017 by a well-known public litigant, Ashwin Upadhyay. Then a petition was filed in forms, and the lawyer in that petition also was Prashant Bhushan. And then in 2022, a petition was filed by Jaya Thakur, who apparently is a Congress member. And so these 4 petitions comprised the totality to which the bench responded. Obviously, it was first heard by a 3-judge bench, and then this was referred to a constitution bench. And it was a constitution bench consisting of 5 judges, led by Justice Joseph. All the 4 judgments had very similar prayers. They were similar, but they had minor differences, which were not very significant for the purposes of our presentation here. The judgment has several sections. Now, let me just sort of quickly run through some of the important sections. It gives the summary of the arguments given by various lawyers in about 25 odd pages. Then it has a huge section, or maybe it's wrong to call it a section. It's the bulk of the judgment. It's a 203-page section, which is called analysis. And this analysis itself is consisting of more than 26 sections, because it goes from A to Z, and then it goes to A, B, B, C, C, and so on. So the analysis is the meat of the judgment. The analysis begins with a kind of a run through a famous book called The Framing of India's Constitution by B. Shiva Rao, who was involved in that process. This talks about the independence of the Election Commission, the right to vote, etc., as it was discussed in the formative years of the Constitution, and finally how they came to arrive at what the current version is. Then it spends significant amount of time, and actually about 15 pages, on discussing the content of the Constituent Assembly debates. And for those of us who are interested in what might be called constitutional history, this section makes very interesting reading. I myself learned quite a bit from this reading. Then there is a section of 9 pages which says, what does it mean when the Constitution says subject to any law? This phrase is analyzed threadbare to come to the conclusion that Article 324, sub-Article 2 of the Constitution is unique, and its usage of the expression subject to any law is in a different context than for any other article in the Constitution. Then it reviews developments from 1950 on to today, and it sort of lists out all election commissioners and chief election commissioners that have been in position and what happened. Then it takes a detour to discuss the important developments in the history of the Election Commission of India, when it was changed from a single-member commission to a 3-member commission. And then it was reverted back to a 1-member commission. And then it was changed back to a 3-member commission, which was again, both these were challenged in the Supreme Court, and that is discussed in some great length. Then comes a very important section which is called the clamor for reforms. This is one of the lengthier sections of the judgment, as much as 22 pages, because it sort of lists out what have been the recommendations of various committees and how various people have said that there should be reforms to the appointment of election commissioners and so on. Then comes another very big and an extremely important section called separation of powers and judicial activism. This is, I think, the second longest section. It has 29 pages. So the bench spends a significant amount of time on the separation of powers because this is what pertains to the judicial encroachment into the legislative arena, and a lot of that criticism is answered here. Then then about 16 pages are spent on the right to vote, and it is interesting to read how many variations of the right to vote can there be. And when I decided to list them out, I myself was quite surprised. It adds up to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. The right to vote has been described in 10 different ways, which I will come to when we reach there. Then the next section deals with Article 326, which is also 29 pages, second longest, because that article is of critical importance. Then it talks about democracy and the importance of elections, the powers, functions, jurisdiction of the Election Commission, the impact of Article 329B. Then there is a very brief section of just about 2 pages which talks about the pursuit of power. Is power a means to an end, or is it an end in itself? This is very important, and I'll spend time on this. Then it talks about the rule of law, fundamental rights, and the independence of the Election Commission. Then there is another fairly big chapter called the Symbols Order and the Model Code of Conduct, which is 18 pages. Then it has perhaps the crux of the whole issue for this session. There's a little section on independence, a sterling attribute, a sterling indispensable attribute. And the judgment spends 4 pages on it, but I think those pages are worth their weight in gold. Then it takes a detour into the appointment of an election commission, which happened while the case was being heard in the Supreme Court. This is actually, I think, a very unique occurrence, that the issue which was being discussed in the court was actually taken up by the executive, and its one election commissioner, the vacancy which had been there for about 8 months was filled while the judgment was being on, and therefore it caused the bench to seek all the information, and then they've analyzed what happened at that time. Then comes perhaps the most important, which is the answer to all criticism. Is there a vacuum in Article 324? And if there's a vacuum, should the court intervene? And this is much as 36 pages. So the criticism or the justification that the court gives, that is there a vacuum? And if there is a vacuum, should the court intervene, is dealt with at some length on a concept called principle of constitutional silence. What does it mean when the Constitution is silent on something? It does not specify something. And is the silence deliberate, or is it an accident, and so on and so forth? Then there is a little mention of something called constitutional morality, which I think is very important in the time that we live in. And then finally, it goes on to make recommendations and so on. Let me then launch into the what I said, some of the topics that I will deal with. And let me first go to independence. And this is when I start reading from the judgment. Now, independence can be thought of, I think of, in two ways. It could be a characteristic, or as the judgment says, an attribute of a person. And it could also be a function of the way a situation is created in which a person functions. The situation can either assist in increasing independence or strengthening independence, or the situation can work towards reducing the independence. Similarly, or not really similarly, differently, independence could be a person is independent or a person is not independent. This is what the judgment spends time on. The heading is independence, a sterling and indispensable attribute. Then the subheading is the concept of legitimate power of reciprocity. Now, the section begins with what is independence, and I'm reading from the section, so I should say quote. Independence is a value which is only one of the elements in the amalgam of virtues that a person should possess. So it is not only one virtue that a person is expected to possess, it is an amalgam of virtues. Competence of a man is not to be conflated with fierce independence. And unquote, this is my own comment here, that the usage man is in the older way includes women, and therefore the judgment is not very politically correct on that count. So I will read it as it is. Let me begin again. Independence is a value which is only one of the elements in the amalgam of virtue that a person should possess. The competence of a man is not to be conflated with fierce independence. A person may be excellent at his chosen vocation. He may be an excellent administrator. He may be honest. But the quality of independence transcends the contours of the qualities of professional excellence, as also the dictates of honesty. We may, no doubt, clarify that ordinarily honesty would embrace the quality of courage of conviction, flowing from the perception of what is right and what is wrong. Irrespective of consequences to the individual, an honest person would ordinarily unrelentingly take on the high and mighty and preserve the righteous path. And here, unquote, here is a key sentence. Quote, an election commissioner is answerable to the nation. The people of the country look forward to him so that democracy is always preserved and fostered. Now, this, I think, is the essence of this section. The judgment goes on to say, we may qualify the above observation by stating that the true independence of a body of persons is not to be confused with sheer unilateralism. This means that the Election Commission must act within the constitutional framework and the laws. It cannot transgress the mandate of either and still claim to be independent. Riding on the horse of independence, it cannot act in an unfair manner either. Independence must be related finally to the question of what is right and what is wrong. A person who is weak-kneed before the powers that be cannot be appointed as an election commissioner. A person who is in a state of obligation or fails the nation. A person who is in a state of obligation or feels indebted to the one who appointed him fails the nation and can have no place in the conduct of elections, forming the very foundation of democracy. An independent person cannot be biased. holding the scales evenly, even in the stormiest of times, not being servile to the powerful, but coming to the rescue of the weak and the wrong, who are otherwise in the right, would qualify as true independence. Upholding the constitutional values, which are in fact a part of the basic structure, and which include democracy, the rule of law, the right to equality, secularism, and the purity of elections, otherwise would indeed proclaim the presence of independence. Independence must embrace the ability to be firm even against the highest, not unnaturally. Uncompromising fearlessness will mark an independent person from those who put all they hold dear before their karma. It is in this context that we feel advised to refer to the following discussion in a particular case where they mention that there is something called a power of legitimate power of reciprocity, which is actually a bit of academic research from the social sciences, where the bench in the case which is being quoted says that it is a legitimate. In addition to having dealt with various psychological reasons which influence the personality of an individual, reference was also made to the legitimate power of reciprocity. It was pointed out that the reciprocity norm envisaged that if someone does something beneficial for another, the recipient would feel an obligation to reciprocate. I helped you when you needed it, so you should feel obligated to do this for me. Now, this, the authors claim, is the inherent need of power is universally available in the subconscious of the individual. The point is, this section ends up saying it is important that the appointment must not be overshadowed by even a perception that a yes man will decide the fate of democracy and all that it promises. And the last sentence is, certainly the darkest apprehensions of the founding fathers, as buttressed by the reports and other materials, unerringly point to the need of the imperative need to act. Now, my reason for reading this out is because the judgment has not merely gone by the arguments given by the petitioners. The bench has actually done its own research, whether it is in Supreme Court judgments or in the social sciences, and looked at the phenomenon of independence and the phenomenon of power. Then it is in the same context that there is a section called the pursuit of power. And let me now turn to that, which of course chronologically in this judgment comes before what I read. Now this section is the pursuit of power, a means to an end or an end in itself. This is critical for what the judgment deals with. And I begin, quote, the basic and underlying principle central to democracy is power to the people through the ballot. Abraham Lincoln declared democracy to be the government of the people, by the people, for the people. A political party or a group or a coalition assumes reins of governance. The purpose of achieving power is to run the government. No doubt, the government must be run in accordance with the dictates of the Constitution and the laws. Political parties not unnaturally come out with manifestos containing a charter of promises they intend to keep. Without attaining power, men organized as political parties cannot achieve their goals. Power becomes, therefore, a means to an end. The goal can only be to govern so that the lofty aims enshrined in the directive principles are achieved, while observing the fundamental rights as also mandate of all the laws. What is contemplated is a lawful government. So far, so good. But what, however, is disturbing and forms, as we understand, the substratum of the complaints of the petitioner is the pollution of the stream or the sullying of the electoral process, which precedes the gaining of power. Can ends justify the means? There can be no doubt that the strength of a democracy and its credibility, and therefore its enduring nature, must depend on the means employed to gain power being as fair as the conduct of the government after the assumption of power by it. The assumption of power itself through the electoral process in a democracy cannot and should not be perceived as an end. The end, at any rate, cannot justify the means. The means to gain power in a democracy must remain wholly pure and abide by the Constitution and the laws. An unrelenting abuse of the electoral process over a period of time is the surest way to the grave of the democracy. Democracy can succeed only insofar as all stakeholders uncompromisingly work at it. And the most important aspect of democracy is the very process, the electoral process, the purity of which alone will truly reflect the will of the people, so that the fruits of democracy are truly reaped. The essential hallmark of a genuine democracy is the transformation of the ruled into a citizenry clothed with rights, which in the case of the Indian Constitution also consist of fundamental rights, which are also being freely exercised, and the commitment and radical change of the ruler from an emperor to a public servant. With an accumulation of wealth and emergence of near monopolies or duopolies, and the rise of certain sections. Oh, there is a little problem. Sorry. With the accumulation of wealth and the emergence of near monopolies or duopolies, and the rise of certain sections of the media, the propensity for the electoral process to be afflicted with the vice of wholly unfair means being overlooked by those who are the guardians of the rights of the citizenry, as declared by this court, would spell disastrous consequences. Now, I decided to spend time on these two relatively smaller sections to show that the bench was conscious of the larger, broader, and deeper issues underlying the independence and neutrality of the election commissioner and chief election commissioner. As a matter of fact, as I was reflecting on what I was to speak today, a thought crossed my mind that maybe the topic would have been more accurately be called neutrality and independence of the CEC and the election commissioners of India, and the role of their appointments in it, because we are not trying to ensure that there should be independence and neutrality in the appointment process. We are trying to ensure that the appointment process should be such that independent and neutral persons get appointed as the outcome of that process. The next section that I thought might be useful is on the separation of powers. Let me now then turn to that. This section, separation of powers and judicial activism, begins with a survey of several judgments, several earlier judgments, which have commented on the issue of separation of powers. Now, of course, most of us who know about it know that there was a French philosopher called Montesquieu, which came up with the principle of separation of powers and checks and balances. And there are these three pillars of the state called the legislature, the executive, and the judiciary. And the normal conception of the three is that the legislature makes the laws, the executive implements the laws, and the judiciary interprets the laws. Now, this is a classical and perhaps a simple, straightforward description. But when it comes to real implementation and application, it becomes a little complicated. Now, this has been discussed time and again, and one of the judgments that the judgment in question quotes contained this paragraph, the beginning of the quote, and yet it is all well recognized that in a certain sphere, the legislature is possessed of judicial power. The executive possesses a measure of both legislative and judicial functions, and the court, in its duty of interpreting the law, accomplishes in its perfect action in a marginal degree of legislative exercise. Nonetheless, a fine and delicate balance is envisaged under our constitution between these three primary institutions of the state. What this means is that when it comes to really performing their functions in the day-to-day operations of a state, these three pillars do not necessarily, they are not pure and unadulterated. The executive exercises some judicial power, some legislative power. The legislature exercises some judicial power, etc. For example, when the legislature tries a member or a member of the public for having done something in contempt of the legislature, and there are cases when the parliament puts a person into custody for 1 day or 24 hours or something, those are actually judicial functions. Similarly, the other two branches do the same. So it is very difficult to draw a clear-cut line between the three. There's another quote in the famous case of Indira Nehru Gandhi versus Raj Narayan. Some of the senior members in the audience would remember these names. And the quote says, "But the principle of separation of powers is not a magic formula for keeping the three organs of the state within the strict confines of their functions." Now, this goes on. Let me therefore go a little further and find some more relevant quotes. There is also a view of the bench which says the theory that the courts cannot or do not make laws is a myth which has been exploded a long time ago. Then they quote a judgment of a 2007 case in the Supreme Court, the state of UP versus Jeet S. Bisht, where the judgment said, the judge-made law is now a well-recognized activity throughout the world. If one is to put the doctrine of separation of powers to such a rigidity, it would not have been possible for any superior court of any country, whether developed or developing, to create new rights through interpretive process. If we notice the evolution of separation of powers doctrine, traditionally the checks and balances dimension was only associated with governmental excesses and violations. But in today's world of positive rights and justifiable social and economic entitlements, hybrid administrative bodies, private functionaries discharging public functions, we have to perform the oversight function with more urgency and enlarge the field of checks and balances to include government inaction. So the checks and balances does not only mean that when one pillar does something which it should not do. It also includes when one pillar does not do what it is supposed to do. Uh, Otherwise, we envisage the country getting transformed into a state of repose. Social engineering as well as institutional engineering, therefore, forms a part of this application, this obligation, which means that if one pillar does not do its job, it becomes incumbent on the other two pillars to step in and do that. The court refers to what is called creative judicial activism as being a subject of both controversy, reaching brickbats as also bouquets to the courts. Under the Constitution, which clothes both citizens and persons with fundamental rights, besides tasking the state with the achieving of goals declared in the directive principles, judicial activism, as opposed to a mere passive role, may be the much needed choice. Then, finally, in this section, the judgment quotes one of my favorite judges of the US Supreme Court, whose statement is part of the is not part of the is the tagline of our organization, the Association for Democratic Accounts, and the tagline is, "No job in the land is more important than that of being a citizen." And this judge was somebody called Felix Frankfurter, who had been made into a judge of the Supreme Court straight from being a professor in a university, a professor of law. On this issue of separation of powers, this is what Felix Frankfurter wrote. All power is, in Madison's phrase, quote, of an encroaching nature, unquote. Judicial power is not immune against such human weakness. It also must be on guard against the encroaching beyond its proper bounds, and not the less so since the only restraint upon it is self-restraint. Rigorous observance of the difference between limits of power and wise exercise of power, between questions of authority and questions of prudence, requires the most alert appreciation of this decisive but subtle relationship of two concepts that do easily coalesce. No less does it require a disciplined will to adhere to the difference. It is not easy to stand aloof and allow want of wisdom to prevail, to disregard one's own strongly held views of what is wise in the conduct of affairs. But it is not the business of this court to pronounce policy. It must observe a fastidious regard for limitations on its own power, and this precludes the court's giving effect to its own notions of what is wise or politic. That self-restraint is of the essence in the observance of the judicial oath, for the Constitution has not authorized the judges to sit in judgment on the wisdom of what Congress and the executive branch do. Congress here is the US Congress. Then a very well-known legal luminary in India, Mr. S.P. Sathe, has written in his book, Judicial Activism. There's a chapter called Legitimacy of Judicial Activism. And I will read this little section because I think it is very important. The realist school of jurisprudence exploded the myth that judges merely declare the pre-existing law or interpreted it and asserted that judges made the law. It stated that law was that what the court said it was. This is known as legal skepticism and was really a reaction to Austin's definition of law as a command of the political sovereign. According to the analytical jurisprudence, a court merely found the law or merely interpreted the law. The American realist school or jurisprudence asserted that the judges made law, though interstitially. Jerome Frank, Justice Holmes, Justice Cardozo, and Llewellyn were the chief exponents of the school. The Indian Supreme Court not only makes law as understood in the sense of realist jurisprudence, but actually has started legislating exactly in the way in which a legislature legislates. Judicial lawmaking in the realist sense, in what the court does when it expands the meaning of the words personal liberty or due process of law or freedom of speech and expression. Now, these are instances where, for example, in the first ADR case, when it was said that when a person, a voter, exercises his right to vote in the booth, he or she needs to know the antecedents of candidates contesting the election. And that right to know becomes a fundamental right, like the right to expression of freedom of expression and speech. To express one's choice, one needs to know. So this is an expansion of the right to freedom of expression and speech, and that can only happen when there is what is called judicial expressiveness. In reality, and I come back to the judgment, in reality, such watertight separation exists nowhere and is impractical. Broadly, it means that one organ of the state should not perform a function that essentially belongs to another organ. The making of an entirely new law, which the Supreme Court has been doing through directions in the above mentioned cases, is not a legitimate judicial function. Then there are sections on whether a judge is a legislator. And here I love the sentence. It says, no doubt the limits for the judge are narrower. He legislates only between gaps. He fills the open spaces in law. How far he may go without traveling beyond the walls of the interstices cannot be staked out for him upon a chart. He must learn it for himself as he gains some sense of fitness and proportion that come with years of habitude in the practice of an art. Even within the gaps, restrictions not easy to define but felt, however impalpable they may be, by every judge and lawyer, hedge and circumscribe his action. So the point is that there are no watertight compartments within which these three pillars operate, and there is a formal democracy and there is a substantive democracy. In substantive democracy, such things do occasionally come across, and you sort of go through these. Then we come to the last and the most important section, which is there a vacuum? Now, this, I don't know how to manage this, because this is a very large section, and the judgment begins with reviewing all possible cases. But the crux of this is the case called Vineet Narayan and others versus the Union of India, and another which was also popularly called the Jain Hawala case, which some of us would remember. In that case, the Supreme Court laid down some rules for the CBI and put the CBI under the supervision of the Central Vigilance Commission. All that is discussed in great detail, but ultimately the conclusion that this bench came to was the following, if I can find it. Yes. let me begin here. While this court is neither invited nor, if it is invited, would issue a mandamus to the legislature to make a law, as contemplated in Article 324(2), it may not be the end of its duty in the context of the provision in question. We have already elaborated and found that the core values of the Constitution, including democracy, the rule of law, are being undermined. It is also intricately interlinked with the transgressions of Article 14 and 19. Each time on account of a knave, Knave, in the words of Dr. Ambedkar, or again in his words, quote, a person under the thumb of the executive, unquote, calls the shots in the matter of holding of elections, which constitute the very heart of democracy, even formal democracy, which is indispensable for a body politic to answer the description of our democracy, is not realized. In the unique nature of the provision we are concerned with, and the devastating effect of continuing to leave appointments in the sole hands of the executive on fundamental values, as also the fundamental rights, we are of the considered view that the time is ripe for the court to lay down norms. In other words, the vacuum exists on the basis that, unlike other appointments, it was intended all throughout that appointment exclusively by the executive was to be a mere transient or stopgap arrangement, and it was to be replaced by a law made by Parliament, taking away the exclusive power of the executive. The conclusion is clear and inevitable, and the absence of law, even after 7 decades, points to the vacuum. The case that it was that in section 324 of the Constitution of India, which set up the Election Commission, Article 324(1) says the superintendent's direction and control of the preparation of so-and-so shall be vested in a commission referred to as the Election Commission. Sub-Article 2 says the Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix, and the appointment of the Chief Election Commissioner and the other election commissioners shall, subject to the provisions of any law made in that behalf by the Parliament, be made by the President. Now, the whole matter rested on whether the appointment of election commissioners and the Chief Election Commissioner being done by the President on the advice of the Cabinet, which means on the advice of the Prime Minister, which has been done all these 75 years, without the Parliament having made the law that it was supposed to have made. Subsequent to the Constitution coming in force, the Parliament made the Representation of People Act 1950. It made the Representation of People Act 1951. It made, subsequent to the formation of the Goswami Committee in 1990, it made the election commissioners' conditions of employment and other matters related to Act in 1991. But no act has been made by the Parliament about the appointment of election commissioners. And the fact that the appointment of Mr. Arun Goel happened while the case was being heard, and when the bench called for the file, they found that from the initiation of the process till the appointment, everything was done in exactly less than 24 hours. Now that, I think, was a very important factor which made the bench think that there was something missing in the appointment process. Let me read one paragraph, and then I think I will stop this practice of reading, because I think it can get quite boring. There is a sentence where they say that, yes, when it was pointed out that it remained a mystery to the court that, incongruous with the unambiguous mandate of Section 4 of the 1991 Act, all the panelists were either retired, 3 out of 4, etc., etc. The bench was kind of could not figure out how this happened. And then they concluded by saying, sorry, apologies. Yes. It was while so on the next day, that is 18/11/2022, when an interim application was also pending consideration of this court, all the procedures commencing with the proposal, processing of the same at the hands of the Minister of Law, the further recommendations of the concerned officers, the recommendation of the Prime Minister, the acceptance of the application of the appointee seeking voluntary retirement, waiving the 3-month period, and the appointment by the President under Article 324(2), which came to be notified, took place in a single day. I think this was one of the, perhaps it was a fortuitous fact that this happened, but the fact that this happened, I think made the bench feel that this was a little too much and something needed to be done. Finally, the bench gave the direction that the appointment of election commissioners and chief election commissioner would be done by a committee consisting of the president, the leader of the opposition in the Lok Sabha, and if there is no formal leader of the opposition in the Lok Sabha, the leader of the largest party in the Lok Sabha, and the Chief Justice of India. Now, this is the final order, and on this order, it is expected that all future appointments will happen. We in ADR have also filed a petition challenging the appointment of Mr. Arun Goyal, which was done while the proceedings were going on, because we had filed an application saying that no appointment should be made till this case is decided. What happens to that petition will remain to be seen. I now come to the final section, that what could have been done. Now, in this case, I think the judgment was reserved. Where is my piece of paper? Yes, the judgment was reserved on November 24, 2022, and it was finally delivered on March 2nd, 2023. Now, in between minds of several of us, and over a period of time, I came to feel that this, the Prime Minister, the leader of the opposition, and the Chief Justice, is more or less identical to what has been specified for the Director of CBI, the Chief Information Commissioner, and so on. And the results have not been very, very satisfactory, because there is always more or less that the Prime Minister and the Leader of the Opposition do not agree, and it depends on which side does the Chief Justice or the representative of the Chief Justice vote, and when the Chief Justice votes with the Prime Minister, the Leader of the Opposition writes a note of dissent, and the process continues. So I wrote a piece December 22, 2022, wherein I began by quoting the speeches or quoting paragraphs from the speeches of Dr. Ambedkar on 25th of November 1949 in the Constituent Assembly, and by Dr. Rajendra Prasad, who was the President of the Constituent Assembly on November 26, 1949. These were their last speeches in the Constituent Assembly, and in which they mentioned basically what they said was that however good a constitution may be, if it is implemented by people who are not good, the constitution would not achieve its purpose. But if a constitution was not very good, but it was implemented by people who were very good, the results would be good. So they actually made a point that the quality of the constitution is less important than the quality of people who implement that constitution. On that basis, I also said that the position of election commissioners and chief election commissioner are so critical to democracy that they cannot be treated like any other position, like the director of CBI or the chief vigilance commissioner and so on. And my fundamental premise was that for the health and well-being of democracy in the country, election commissioners should have the confidence of the parliament. And confidence of the parliament should not only be on the basis of a simple majority, it should be on the basis of a two-third majority. And I laid down a process in that article, which some people said will be very cumbersome and so on, but I was secretly hoping that this will come to the notice of the judges and they might include it in the judgment, but obviously that did not happen. Now, be that as it may, while I was reading the judgment, I was very pleasantly surprised that in the discussion of the Constituent Assembly debates called Professor Shibbal Lal Saxena actually had said exactly what I had written in my piece. It is not to say that I thought it was a great thing, but I felt very gratified that the issue was not something that I thought was very good. But it had been thought of earlier also by people who were much bigger and better than I could ever be. And Mr. Shibbal Lal Saxena or Professor Shibbal Lal Saxena said, he made this statement, and I quote, and this is in the judgment: of course, it shall be completely independent of the provincial executors, but if the president is to appoint this commission, naturally, it means that the Prime Minister appoints this commission. He will appoint the other election commissioners on his recommendations. Now, this does not ensure their independence. Let me just add one or two other things. So what I want is this, that even the person who is appointed originally should be such that he should be enjoying the confidence of all parties. His appointment should be confirmed not only by majority, but by two-thirds majority of both houses. If it is only a bare majority, then the party in power could vote confidence in him. But when I want two-third majority, it means that the other parties must also concur in the appointment, so that in order that real independence of the commission may be guaranteed, in order that everyone, even in the opposition, may not have anything to say against the commission, the appointments of the commissioners and the chief election commissioner must be made by the president, but the names proposed by him should be such as command the confidence of two-thirds majority in both houses. He goes on to say further, I want that in future no prime minister may abuse this right. For this, I want to provide that there should be two-thirds majority which should approve the nomination by the president. Of course, there is danger where one party is in a huge majority. As I said just now, it is quite possible that if our prime minister wants, he can have a man of his own party. But I am sure he will not do it. Still, if he does appoint a party man and the appointment comes up for confirmation in a joint session, even a small opposition or even a few independent members can down the prime minister before the bar of public opinion in the world. Because we are in a majority, we can have anything passed theoretically. So the need for confirmation will invariably ensure a proper choice. So the point that I am trying to make is that none of these actions that we take in our and the country's best interest can never be the best for all time to come. Things can be improved as we go along, and we must continue to try and improve them as we go along. And finally, as the judgment also says, not in these words, but indirectly, that the answer to this is eternal vigilance by the people. And that, I think, is the last word on democracy. If we want to save, protect, and preserve democracy, we need neutral and independent people forming the election commission. But however good those people may be, unless all of us are vigilant, I think democracy will always be in danger. And therefore, the saying that democracy is not a destination, democracy is a journey. And on that journey, all of us have to be eternally vigilant. So thank you very much. I will stop here, and we shall take questions if there are any. Thank you very much.